Here's a good one for you guys. So, got a client down in Virginia, and pretty shitty situation the way his case worked out. Went to trial, got found guilty, had ineffective assistance of counsel. However, counsel says to him at the conclusion of the trial, hey, listen, I'm gonna go ahead and fall on the sword, man. So we need to appeal this. So then he files a notice of appeal and then doubles back and tells the client, I don't see any merit to any appeal, so I'm not going to be presenting an appeal brief. But if you want to come back on a state level habeas and get me for ineffective assistance of counsel, that'll be fine. Now, the problem with that is that he basically left his client abandoned and in pro se status. So that client contracted with our office, and we worked with him to put together a very formative, legally sound opening brief, which went to the Court of Appeals. Now, when the Court of Appeals got the brief, apparently they looked at it and had questions as to why counsel of record did not do an appeal when there were clearly errors or assignments of error that were at contention. So what this guy does, the attorney, is he hauls ass over to the prison where the offender is at and tries to convince the offender to withdraw the opening brief and stick to a habeas corpus for ineffective assistance of counsel, knowing full well that it is very, 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 very difficult to prove ineffective assistance of counsel. So in essence, what this attorney did was sabotage this young man, or attempt to sabotage this young man's chances at post-conviction. And that's the kind of sliminess that makes me very leery of the individuals that we put our faith and trust in to go in and represent our loved ones. So I wanted to drop that on you. What's y'all's opinion?